So what are the individual rights that are guaranteed under the Constitution of the state of California? The most extensive provisions of the California Constitution and the article that has by far the most reported appellate court decisions, bar none, is the first article, Article 1, that deals with the Declaration of Rights, originally adopted in 1879 with the adoption of the second Constitution of the state. Article 1 contains 32 sections. So I wanted to go through them and briefly discuss what those individual rights are under Article 1 of the California Constitution. Section 1 states that all people are by nature free and independent, and they have inalienable rights. And among those are enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety, happiness, and privacy. Section 2 provides that every person may freely speak, write, and publish his or her own sentiments on all subjects, being responsible for the abuse of this right. And a law may not restrain or abridge liberty of speech or press. Section 3 specifies that the people have the right to instruct their representatives, to petition government for the redress of grievances, and assemble freely to consult for the common good. This section provides that the people have the right of access to information concerning the conduct of the people's business, and therefore they have access to the meetings of public bodies, and the writings of public officials and agencies must be open to public scrutiny. In addition, Section 3 has numerous provisions related to privacy protections and specifically protections of certain information. It also requires public access to the meetings of public bodies and the writings of public officials and agencies. Section 4 provides that the free exercise and enjoyment of religion without discrimination or preference are guaranteed, and that the legislature must not make any law respecting an establishment of religion in the state. Section 5 requires that the military be subordinate to the civil power. In addition, a standing army may not be maintained in peacetime, and soldiers are prohibited from being quartered in any house in wartime, except as prescribed by law, or in peacetime without the owner's consent. Section 6 specifies that slavery is prohibited and involuntary servitude is prohibited except to punish crime. Section 7 provides that a person may not be deprived of life, liberty, or property without due process of the law, or denied equal protection of the laws. There are also numerous provisions in this section that deal with school transportation and integration plans, and a citizen or class of citizens may not be granted privileges or immunities that are not granted on the same terms to all the citizens. Section 7.5 contains a limitation on marriage, but this section was declared unconstitutional in 2010 by the federal courts. Section 8 of Article 1 prohibits a person from being disqualified from entering or pursuing a business, profession, vocation, or employment because of their sex, race, creed, color, or national or ethnic origin. Section 9 provides that a bill of attainder, an ex post facto law, or a law impairing the obligations of contracts may not be passed. Section 10 specifies that witnesses may not be unreasonably detained. In addition, a person may not be imprisoned in a civil action for debt or tort, or in peacetime for a militia fine. Section 11 provides that habeas corpus may not be suspended unless it's required by public safety in the case of either rebellion or invasion. Section 12 provides that a person must be released on bail by sufficient sureties, except in the cases of capital crimes, felony offenses involving acts of violence on another person, or felony offenses where the facts are evident or the presumption great and the court finds on clear and convincing evidence that that person has threatened another with great bodily harm. Section 13 provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable seizures and searches may not be violated, and a warrant may not issue except on probable cause that's been supported by an oath or affirmation with particularity in describing the place to be searched and the persons and things to be seized. Section 14 requires that felonies are to be prosecuted as provided by the law, either by indictment or after examination and commitment by a magistrate by information. And section 14.1 of Article 1 specifies that if a felony is prosecuted by indictment, there cannot be a post-indictment preliminary hearing for the defendant. Section 15 provides that a defendant in a criminal case has the right to a speedy public trial, to compel the attendance of witnesses on behalf of the defendant, to have the assistance of counsel for their defense, to be personally present with counsel, and to be confronted with the witnesses against the defendant. In addition, this section provides that persons may not be twice be put in jeopardy for the same offense, or be compelled in a criminal case to be a witness against themselves, or to be deprived of life, liberty, or property without the due process of law. Section 16 states that trial by jury is an inviolate right and must be secured to all persons, but in a civil case, 3/4 of the jury may render a verdict. A jury may be waived in a criminal case by the consent of both parties expressed in open court by the defendant, as well as the defendant's counsel. In a civil case, a jury may be waived by the consent of the parties as prescribed by state statute. In addition, Section 16 provides that in civil cases, the jury must consist of 12 persons or a lesser number agreed to by the parties in open court. In civil cases other than cases within the appellate jurisdiction of the Court of Appeal, the legislature may provide that the jury consist of 8 persons or even a lesser number that's agreed to by the parties in open court. And finally, under Section 16, in criminal actions in which a felony is charged, the jury must consist of 12 persons. In criminal cases in which a misdemeanor is charged, the jury must consist of 12 persons or a lesser number that's been agreed to by the parties in open court. Section 17 states that cruel or unusual punishment may not be inflicted or excessive fines imposed. Section 18 provides that treason against the state of California consists only in levying war against it, adhering to its enemies, or giving them aid and comfort. A person may not be convicted of treason except on the evidence of 2 witnesses to the same overt act or by the defendant's confession in open court. Section 19 provides that private property may be taken or damaged for a public use only when just compensation ascertained by a jury, unless that jury's been waived, has first been paid to or placed in court for the owner of that property. In addition, the state and local governments are prohibited from acquiring by eminent domain an owner-occupied residence for the purpose of conveying it to a private person. This section 19, also provides definitions for the terms conveyance, local government, owner-occupied residence, person, public work or improvement, and state. Section 20 of Article 1 provides that non-citizens have the same property rights as citizens do. Section 21 specifies that property owned before marriage or acquired during marriage by gift, will, or inheritance is deemed separate property. Section 22 prohibits the right to vote or hold office from being conditioned by property qualification. Section 23 specifies that 1 or more grand juries must be drawn and summoned at least once a year in each of the 58 counties. Section 24 states that rights guaranteed by the state constitution are not dependent on those guaranteed by the U.S. Constitution. Section 25 provides that the people have the right to fish upon and from the public lands of the state and in the waters thereof, with certain specified exceptions. Section 26 of Article 1 states that the provisions of the state constitution are mandatory and prohibitory unless by express words they are declared to be otherwise. Section 27 of Article 1 states that all statutes of this state in effect on February 17th, 1972 that require, authorize, impose, or relate to the death penalty are in full force and effect, subject to legislative amendment or repeal by statute, initiative, or referendum. In addition, Section 27 provides that the death penalty under state statutes must not be deemed to be or constitute the infliction of cruel or unusual punishment within the meaning of Article 1, Section 6, nor must punishment for these offenses be deemed to contravene any other provision of the state constitution. Section 28 makes numerous findings and declarations by the people of the state of California related to criminal activities, to victims of crime, and to the rights of those victims of crime. In addition, Section 28 specifies that victims of crime have additional rights that are shared with all the people in the state, including the right to safe schools, the right to truth and evidence, public safety bail, the use of prior convictions, truth in sentencing, and reform of the parole process in this state. Section 29 provides that in a criminal case, the people of the state of California have the right to due process of law and to a speedy and public trial. Section 30 provides that the state constitution cannot be construed by the courts to prohibit the joining of criminal cases as prescribed by the legislature or by the people through the initiative. In addition, Section 30 provides that hearsay evidence must be admissible at preliminary hearings as prescribed by the legislature and statute or by the people through the initiative. Section 31 specifies that the state is prohibited from discriminating against or granting preferential treatment to any individual or group of people on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting. And finally, Section 32 of Article 1 requires that certain provisions are enacted to enhance public safety, improve rehabilitation, and avoid the release of prisoners by federal court order, notwithstanding anything else in this article of the Constitution or any other provision of law, including parole consideration and the earning of credits.